Welcome to the Politics Guys. I'm Michael Baranowski, a political scientist at Northern Kentucky University. My guest today is attorney Scott Oswald, a managing principal at the Employment Law Group. He has extensive experience with whistleblower, employment discrimination, and wrongful termination cases. He regularly lectures on employment and whistleblower law, and he's authored numerous articles on federal and state whistleblower and employment law protections. Welcome to the show, Scott.
Hey, I'm happy to be here, Michael. Thanks for having me.
You know, to start with, I was hoping you could maybe clear up some terminology for me. I hear the terms whistleblower and leaker a lot, and I'm wondering if you can explain what exactly they mean.
Yeah, I completely get it. I mean, you hear it a lot out there. It's almost interchangeable in the media, but they really do have distinct definitions, both under the law in particular, and really in how it's used in the federal sector. So let's look at it. I mean, a whistleblower really is somebody who is disclosing information that ultimately is for the public good. The purpose behind the disclosure generally is to get the information to people who, maybe it's an organization, maybe it's a government agency that actually can do something about it. The nature of the disclosure itself, the extent of the disclosure, is just enough to do that, to meet that purpose. So we're not, for instance, just disclosing information indiscriminately. And really, the person is using an established mechanism. So a mechanism that either is provided for by law or provided for by the organization, with the expectation then that the organization itself will do the right thing and in fact investigate. And what the law then requires organizations to do is actually to do something with that information. Assuming a whistleblower does her part and actually discloses using that established mechanism, then there are rules out there for publicly traded corporations in the federal sector space as it relates to, for instance, sexual misconduct, that requires an organization then to investigate and then promptly do something about the underlying allegations. Leaking is very different. Leaking is where maybe an individual is providing the information for reasons apart from rather the public good, as an example. Indiscriminately disclosing information, for instance, to WikiLeaks, where there might be another alternative that is provided for by law, and where the individual is not careful in terms of what they're disclosing. For instance, classified information would potentially put us into the realm of being a leaker as opposed to someone that is in fact a whistleblower. So a whistleblower is someone who's doing the right thing, following the established mechanism, and really disclosing only what is necessary in order to potentially correct the harm or the illegality.
Right. So it sounds like established mechanism is a really important part of that. If I'm understanding you correctly, then.
It really is, and there are rules. For instance, the Securities and Exchange Commission has rules that require certain types of whistleblowers, attorneys, accountants, people who are in, let's say, the audit function, to actually use that mechanism first before they go outside the organization, and that's a requirement of those rules. And the Department of Justice, when evaluating whistleblowers, for instance, in the space that deals with public monies, will give additional credit to individuals who have disclosed in their corporations internally first, as an example. So identifying the appropriate mechanism for whistleblowers is important, and if they follow that mechanism, then they're going to be on really firm ground.
So then, by that sort of definition, Edward Snowden, Chelsea Manning, they would be not whistleblowers, but I guess you'd call them leakers, right?
I'll tell you that that's a tough, certainly as it relates to Edward Snowden. I think it's a tough call. I mean, we have a judge that has come out, a very conservative judge in our federal district court here, that has said that what Edward Snowden disclosed was illegal behavior on the part of the federal government. And that's the classic type of information that, if disclosed by an individual, would bring them well within the realm of being a whistleblower. So from that perspective, I think that very much inures to his benefit. The problem, I think, with Edward Snowden, and certainly is the issue with Chelsea Manning, is the extent to which information was disclosed. I mean, in Edward Snowden's case, as an example, the fact that we were monitoring the communications of foreign leaders, that's not illegal, and certainly was classified. And so the fact that he disclosed that information along with what turns out to have been illegal, then is kind of a strike against him, if you will. So I think that both of those are tough calls, but to the extent that they can be called up short, it's the fact that they indiscriminately disclosed information rather than disclosing information in a targeted way and only enough to expose the illegality.
Yeah. So it sounds like that gets into a really sort of tricky part when you're talking about classified information. Any sort of release of it, of course, would, I guess, by definition, be illegal. And so if the classified activity also happens to be itself illegal, it's kind of it puts a person in sort of a difficult position.
It really does. And you can imagine someone in that situation saying, look, I mean, I don't even think that this should be classified information. And how can a government's agency's illegal conduct be classified? I think those are really good points. And that's the conundrum that someone who is in the classified space is in. So, what do you do? I mean, if you have a security clearance, you have access to classified information, you know that what you've discovered, in fact, would constitute illegal behavior that that ought to be exposed. Well, there are some mechanisms that an individual has, some options they have in that situation, and the first is a disclosure to the Inspector General within the agency. And the Inspector General's Act requires agencies to create separate functions within that agency, the Inspector Generals, whose responsibility is rooting out corruption and illegality in those agencies. So that's a really good first place to start. And the law provides protections for individuals who use that route. So that's a really good place to begin. The second possibility is to disclose to Congress. So, we have a different branch of government here. There is a mechanism by which one can disclose information that is classified to a congressional committee that has the responsibility for the oversight of that area, and the individuals on that committee are themselves going to be cleared to view that information. It has to be carefully done. There are some prerequisites that a whistleblower would have to meet, but that's a possibility. And the final possibility is to actually notify the third branch of government, the judiciary, and to file a complaint under seal with a federal district judge to notify that federal district judge that, in fact, illegality has occurred. And the mechanism, one of the mechanisms to do that would be a statute called the False Claims Act, which was passed in the wake of the Civil War and championed by President Lincoln in 1863. But this would be a way to notify a federal judge, like one of our federal judges here in the district, that found that the government was engaged in illegal behavior, that in fact that illegal behavior was occurring, in the first instance.
And do you think that employees of the federal government or state governments, I guess, are aware of these options? I'm thinking again, in terms of say someone like an Edward Snowden, would he, you think, have been aware of these options that would have put him in, I guess, a lot better position legally than the route that he chose to take?
I suspect that a lot don't. And this is a fault of both our contracting system and in those arms within agencies that are responsible for disseminating information about these various options to employees. So one of the things that is required of contractors when they contract with the federal government is they're required to disseminate to their employees information about disclosure, potential illegality that employees may come upon, and the option in particular to go to Inspector General with that information. Unfortunately, what we see is that many of these contractors don't conduct that training. They just simply don't do what they're required to do under the law to notify employees of the routes that those employees have. And so it is far too infrequent that we see agencies either requiring these contractors to conduct the training, or that the contractors are actually doing it. When they win these awards and they come in to take over that business.
Right. Now, you mentioned that there's an obligation for the organization to consider and act on these claims. But I'm wondering, what about the whistleblower, him or herself? What sort of protections do people who come forward and use the correct mechanism have?
There are a number of different statutes that do protect employees in these situations. An important one is a statute that protects individuals who disclose fraud on the government. And this emanates from the False Claims Act, the one we just talked about earlier. It prohibits an employer from retaliating against an employee because that employee has used the employer's stated mechanism to disclose potential fraud on the United States government. Billing fraud, as an example, healthcare fraud, mortgage fraud, these kinds of things. To the extent that an employee in the private sector is aware of and discloses the information, she can be protected under those circumstances. Federal government contractors have even broader protections in the workplace to the extent that they disclose illegality or a workplace rule violation that relates to that contract, and they do so either internally or to the federal government. They'll be protected from any kind of harm that an employer might mete out. So there are statutes that are out there, and what we see at the Employment Law Group on a routine basis is the fact that employees they know about wrongdoing, they just don't know what the established mechanism is within their company. They don't know that there are protections that apply. So one of the first things we do is we counsel employees to get a copy of their handbook, let's say their employee manual or their internal ethics guide. And most of those manuals or ethics guides will have in there a point of contact, someone that you can go to and disclose information that you believe there might be illegality afoot. And what we recommend is that the employee do so in writing. A lot of employees say, "Look, I don't want to go out on a limb that way. It would be there'd be a record of my disclosure." But it's exactly because there is a record of the disclosure that we recommend it. Then the organization really is compelled to look into it, to investigate. There's no question what the employee in fact disclosed to the organization and when the employee disclosed the information. So at the Employment Law Group, we're always counseling employees to give their employers a chance to do the right thing at the outset, because there really are organizations that will do the right thing, that have an interest in stamping out illegality in the workplace. They just don't know about it, and they need to know about it. But it is that internal disclosure, and doing so consistent with the employer's stated mechanism for disclosure, that is going to trigger the organization's obligations to do something, and will then cloak that employee in the protections of the statutes we've just talked about.
Right. Now, what about at the state level? Do most states have fairly similar protections for whistleblowers, or are there pretty big differences?
There really are big differences, so some states have broad protections, like New Jersey, as an example, which probably has the nation's broadest whistleblower protections for employees of private companies. Other states have protections that are very broad for public employees, those who work for the government or maybe work for a contractor of the government. Still others have very minimal protections. Georgia is a really good example. New York is another good example of that. So it really is going to depend upon the state in which the employee works or where the employer is located, the extent to which those protections apply. So it's always a good thing under the circumstances to just get in touch with a lawyer, to ask questions about, hey, what are those protections? What do I need to say in my disclosure in order to trigger the particular protections that state law might provide under the circumstances, and where to disclose? Because, for instance, an employee who works in Georgia but discloses to their corporate headquarters in New Jersey might, in fact, be protected by New Jersey's law, so long as that employee makes the disclosure, in essence, sends the email to the right place.
Right. Given that there are a lot of differences at the state level, I want to just focus on the federal level for one final question before I move on. Are current whistleblower protections, in your view, at the federal level pretty good, or are there certain changes that you think would improve the situation?
Well, that's a really good question, and in part, the Supreme Court is going to answer that question later this term. It heard oral arguments in a case where the corporate America is arguing that the Dodd-Frank Act's whistleblower protections do not apply to an individual who discloses internally, and that it's only an external disclosure to the Securities and Exchange Commission that will protect that employee in the workplace. Interestingly, this is exactly the opposite of what corporate America was arguing to the SEC when the SEC put its rules in place to implement the Dodd-Frank Act. But if the Supreme Court, as is likely, comes down in favor of an interpretation of the statute where employees are not protected, maybe the most important thing to know is that the protections that are out there require employees to act quickly. The Department of Labor's Office of Safety and Health Administration administers a whole host of statutes. It's more than 20 that protect individuals who work for publicly traded corporations, who work in the nuclear field, surface transportation, airlines, just to name a few. But some of these statutes have very short deadlines, some as little as 30 days. So an employee, in order to protect himself fully, will need to notify the Department of Labor within that very short period of time in order to take advantage of those protections. So it's really important to really talk to a lawyer early, so that you know what protections are out there and by when you have to initiate a lawsuit to the extent you choose to do so.
I'd like to move on now to another area that I really want to talk with you about, another area of expertise for you, and that's employment discrimination and wrongful termination. I guess first off, how big of a problem is this in your view?
I think it's an endemic problem, and we're really seeing some of maybe the not so implicit bias coming to the surface over the course of the last year. But we see, unfortunately, illegal discrimination in the workplace is alive and well, unfortunately, and it manifests itself in many different ways. but there's a real pay disparity between men and women in the workplace. That's not new, but maybe the extent to which it is out there, I think, is maybe coming into sharp focus. We also see still vestiges of race discrimination, national origin discrimination on a routine basis. And what's interesting is that where I think that maybe certain supervisors who maybe harbored these biases were more nuanced in their approach until the last year. What we're really seeing now is people coming forward and really talking about these things, and in a much more open way. And there's, we're also seeing a backlash of political discrimination, quite frankly, views individuals might have on both sides that are getting them into real hot water in the workplace. So I think that it is just as prevalent today as it was, maybe 2 years ago, but I think it's much more in the open today than it was before. And so for civil rights lawyers like myself, it's a real challenge because, what we have to do is not only, uncover it, but then prosecute these actions against companies that in many instances, don't want to do anything about it. So it's a real challenge for sure.
Now, how difficult is that to demonstrate? Because I would think in a lot of cases it would be come down to sort of he said, she said sort of situations, or employers could find plausible reasons for why they didn't promote somebody or give someone a raise, that sort of thing, because so much of this seems to be very subjective. So how does that work exactly?
Yeah, it's a really good question. Well, the way it works legally maybe is a little bit differently than it works in practice before a jury. So just, maybe just a quick distinction. The law provides for, really two ways to show discrimination in the workplace. The first is really that kind of discrimination that's out there in the open, where someone says, look, I'm not giving you the raise because you're female, or, I just don't like you because of your race, or your national origin. Those kinds of situations we're seeing more of, quite frankly, over the last year, but they're still certainly a minority. I mean, most supervisors are, they're more careful and nuanced in really being open about what their true intentions are. It's those cases where someone isn't saying this kind of thing that is harder to prove. And what we're looking at is what the law calls circumstantial evidence. We put people to death in this country on circumstantial evidence every day. And so the law does embrace circumstantial evidence is just as powerful as direct evidence of discrimination, but it's harder to root out. It's harder to show. But generally what we're doing is we're showing that an employer has treated a certain class of individuals very differently than other classes, or that they've violated their own internal protocols, their own internal rules in discipline or in promotion opportunities. When we can show these kinds of things to a jury, we can show that it really goes beyond simply one case, but that there's a larger problem afoot within an organization, juries are more apt to act in those situations than in a one-off case. So what we're looking to do is to show that there's a larger problem within the organization that a jury has to address.
Right. Now, one thing I hear from some people is, well, geez, I'm all for, not having overt discrimination. And of course, I'd never do that. But I feel like things have gotten to the point where I can't make an innocent remark. I have to walk on eggshells around anyone who is maybe of a different gender or of a different race. And so they feel that it seems to me that things have gone too far the other way. I mean, how do you respond to that sort of comment or concern?
Well, I completely get it, and we're hearing a lot of that in the wake of some of the high-profile instances that we're seeing in the media today. But one thing I want to point out is that the allegations against some of the individuals that we've heard about. I mean, they're certainly not in this category. The fact that people are using their power in order to, for instance, compel women to engage in sexual acts or other kinds of behavior that is completely beyond the pale. I mean, that's really what we're seeing right now in the news, and there just is no excuse for any of that under any circumstance. What you're really referring to is a situation where someone might make a one-off comment in the workplace. The thing to know is that the law does not necessarily require an individual be disciplined for the one-off comment. Generally, what's unlawful, and therefore, what a corporation must act upon is a pattern of behavior on the part of somebody. So you're making comments on a routine basis, as an example. But even the one-off comment, if severe enough, can be enough to get you fired, quite frankly, and rightly so. I mean, certain words are inappropriate, and they are inappropriate in any context, including the workspace. And so, my advice to individual employees is really just simply to, not say in the workspace what you wouldn't say to your 9-year-old daughter, quite frankly. And if it's something that you wouldn't repeat in your own house, then don't bring it in the workspace. I mean, that's a pretty clear rule that all of us should follow. And so my sense is that employers have an obligation to create a safe and healthful workspace for all of us. This is the space where we're all thrown together, different backgrounds, different ages, different perspectives, and we have to be sensitive to the point of view of others in the workspace, and employers really walk a tightrope to ensure that that's the case. So we just need to check our biases at the door to the extent that we can.
Yeah, absolutely. The U.S. Equal Employment Opportunity Commission, that's the agency responsible for enforcing federal anti-discrimination laws. And I'm wondering if you've noticed any differences in approach, aggressiveness, or I guess really anything else between the Trump and Obama EEOC.
Well, there sure has been, for sure. First off, I think what's important to know is that we're seeing an uptick in certain kinds of discrimination with the EEOC. For example, we've seen a real uptick in claims of age discrimination in the workplace, and I think that this is a product of really two things. The first is we've got people that are having to stay in the workforce much longer than they otherwise would. The shredding of the safety net that may be coming in Congress, as an example. This has a real impact on real human beings, and if that's allowed to occur, and we see a change in Medicare and Social Security, as an example, it's just going to accelerate this process, and people are going to have to remain in the workplace longer and longer in order to support themselves and their families. So I think that age discrimination claims are going to increase maybe quite a bit over the course of the next 5 to 10 years. We also see an uptick in retaliation claims before the EEOC, where individuals are coming forward. They're coming forward in good faith, and they're experiencing a retaliation. And I think most of the time this is happening because companies don't have vigorous anti-retaliation policies in place in their companies, or if they do, they don't train their employees on those policies. So we're seeing an uptick. I think in the change with the EEOC in particular will be that the EEOC is simply not going to prosecute the number of cases that it did during the Obama administration. The EEOC during the Obama administration was very willing to prosecute individual cases that they felt were meritorious, and that's a real investment of time and resources that the EEOC, I think, was willing to put forward, even though even under the Obama administration, the EEOC's budget remained mostly static. I think what we'll see in the new era of the EEOC is a lot less prosecutions and a lot more what they will call voluntary compliance with employers. The reality is, though, is that there simply is a sector of corporate America that will not comply with our EEO laws unless they're forced to. And so this change, I think, in approach will have a real impact, especially maybe on companies that are not in the top tier, that don't have the kinds of anti-discrimination policies and human resource organizations that are dedicated to eradicating discrimination in the workplace and in their workspace.
Right. And so, one final question for you: are there any changes, whether legislative or in terms of enforcement, that you think would improve on the current state of things in employment law, anti-discrimination?
Well, I do. I mean, if the Supreme Court comes down the way we think it will under the Dodd-Frank Act and finds that internal disclosures do not trigger the protections of that important law, I think that would be a change that Congress can make for sure to protect individuals who disclose potential illegality within publicly traded corporations. Also, another change that has been out there but has not yet been enacted would be a whistleblower provision that would protect individuals who disclose tax wrongdoing, for instance, tax evasion, potential violations of other tax laws. There is not currently a statute to protect individuals who disclose that information within corporate America. So protections for tax whistleblowers would be an important change as well. And maybe given the fact that the Internal Revenue Service has really a decreasing budget and fewer resources to enforce our tax laws, a change in the False Claims Act, which right now excludes tax whistleblowing from its provisions. The reality is that there are literally billions and billions of dollars that are being improperly withheld from the federal government that should be paid as part of corporate America and individual taxes that are escaping detection right now. And if the False Claims Act were changed to include this kind of tax evasion, that would potentially make a huge dent in that area as well. So these are changes that Congress could enact almost immediately to protect the federal fisc in particular, and protect, quite frankly, shareholders who are investing in corporate America from being fleeced, quite frankly.
That sounds like some reasonable changes to me. So with that, we will close. Scott Oswald, thank you so much for taking the time to talk with me today.
Hey, you are welcome. It is my pleasure, and look forward to being with you again.
That's it for this Politics Guys interview. Thanks for listening. We hope you like what you heard. Listener support is really what helps keep the show going. And if you'd like to help us out, you can go to politicsguys.com and click on either the Patreon or PayPal links. And if you want to support the show without spending anything, you can share this episode with your friends and followers, or pass along our new show posts and tweets on Facebook and Twitter. Leaving reviews and ratings on iTunes also really does help. If you want to get in touch with us, you can reach us at mail@politicsguys.com or our Facebook page, where you can message us and where we post stuff throughout the week. That's facebook.com/politicsguys page. We're also on Twitter @politicsguys. The executive producers of the Politics Guys are Michael Baranowski, Jay Carson, Trey Orndorff, and Bruce Johnson. Today's show was produced by Michael Baranowski. We'll be back with a new show on Saturday. We hope you'll join us.